It's absolutely great to be here and great to be talking about supply chains, and hopefully we can build on the comments on the last panel. This matters because, of course, we know from the global slavery estimates that nearly 28 million people across the globe are in forced labour, most of those in forced labour in the private sector. So for me, this is absolutely about prevention and trying to kind of pull on that theme from earlier on. As Lola mentioned, the UN Guiding Principles on Business and Human Rights set out the responsibility of businesses to respect human rights, to avoid infringing on people's human rights, but when there is an infringement, to take action. Where there is impact, they need to be involved. But of course, as we all know, the UN Guiding Principles are voluntary, and therefore step up to Section 54, the Modern Slavery Act. We heard a lot about it in the last session, but I will say, I get all the points about it not being perfect, but talking to businesses, the fact that it has to be signed off by a director and go to the board should not be underestimated, because it put it on the agenda of the C-suite. And I know I also work as well at the Rights Lab for CCLA Investment Management, and we've now done 3 benchmarks of UK companies and more recently global companies. And there is significant difference between the best and the worst. You know, the best companies are doing due diligence. They are finding cases, they are disclosing those cases, and they're doing something about them. The worst companies are taking no action, and they are either reporting in a very kind of perfunctory fashion or not reporting at all. And the point is, there was very, very weak law in terms of an ability to injunct in the Modern Slavery Act. It's never been used. And the issue about sanctions, I think, is absolutely key. As everybody said, the world has moved on in terms of business and human rights. So what are the options? And we're going to cover those. Is it about going back to Section 54 and toughening it up in the way that the last government promised, I think back in about 2020, but never happened, particularly, I think, with regard to sanction? But is it about going further than that, about mandating human rights due diligence? We will cover it in the questions, but if you've been following what happened in the EU, there was a bit of a setback last week, but I don't think it's a complete setback. For those of you who haven't been following it, basically the EU said that they were going to mandate environmental and human rights due diligence. There was then a bit of a kerfuffle towards the end of the last year and said, are we having too much regulation? And there was what's called an omnibus package was published last Wednesday by the EU, scaling back some of the requirements of their corporate sustainability due diligence directive. Basically saying it will only apply to people directly who you have a business relationship with in your supply chain, that you'll only have to do your reviews every 5 years rather than every year. And just generally kind of pulling it back. And implementation has been pushed back a year as well. So a real concern. Now, that's the Commission suggesting that. It might be that the Parliament and Member States don't agree with it. So there's everything to play for, I think, still in the EU. So is that something we should be thinking about? And also forced labour import bans. Already in the States, a bit of a question mark at the moment, but in the EU, that is very much going ahead. This is a really important policy debate, I think, because we know from the little hint we got from the government in the reply to the House of Lords report on modern slavery that they are looking at all this area. So as they look at this area, this is a great opportunity to think about what is the evidence, what is the advocacy points that can be made. So I think it's a very exciting time to be talking about modern slavery in supply chains. And I've got 3 experts with me. First of all, here on my right, Katherine McNulty, who some of you will know. Katherine is the head of enforcement and supply chains in the Modern Slavery Unit in the Home Office. And then next to Katherine is Áine Clarke. Áine is head of KnowTheChain. They also benchmark companies for their activities. And she also heads up investor strategy at the Business and Human Rights Resource Centre, and is a great colleague and a friend of mine. And then lastly, Dr. Sofia Gonzalez, who is a researcher in all matters modern slavery, ESG, business at the Bingham Centre. So you're all very welcome. Now, what we thought we might do, we might be logical and talk about question, first of all, about Section 54. What are your kind of senses of the impact it's had? How should it be strengthened? And then we'll look forward. So Katherine's going to have a go at Section 54.
Yeah, absolutely. Thanks very much. And it's probably something that we're going to hear a lot today about how groundbreaking the Modern Slavery Act was. And I think Section 54 in particular was a real novel measure in that act. If I can start with what the impacts of Section 54 were, and it's really some of the things that you have suggested around getting that spotlight on modern slavery in boardrooms and in businesses that had never looked at this before. And I think that was genuinely the greatest impact that these provisions have had. And it's probably worth remembering that sometimes the most kind of innocuous almost measures to have your statement signed by the board has the most kind of power in terms of the reach and the impact of it. And I think that's an important consideration when we consider some of the kind of bigger policy levers when we get onto it later into the discussion. In terms of how it should be kind of strengthened and how we can improve it, really, I think there's two areas. One has already been alighted on in terms of the enforcement mechanism. Toothless, weak has been said. My polite government version of that is tentative, in that it didn't, the novelty almost of Section 54, I think meant that it was almost too risky, almost too untested to put something, some bigger, harsher enforcement mechanisms in place. And there was probably wisdom at the time that thought an injunction power would do it. With hindsight, I don't think it does. And I think that's something that we really need to look at. And then the second area where I think we could really look to strengthen it is that Section 54 is a reporting requirement. It doesn't ask businesses to take any action. Indeed, you can comply by signing in a statement and saying that you have taken no action at all. So we need to look at ways and mechanisms to move the TISC regime into action rather than just a reporting requirement. So there are two key areas for us to be looking at.
I think a lot of people in the room will really like what you're saying about action as well as reporting. Áine, what are your thoughts on this?
Yeah, I mean, I have to say I agree with everything that Katherine has said in terms of raising awareness. I think from my perspective and the Research Centre's perspective, I think we would be quite critical in terms of the criteria around, the three criteria used in terms of, that a company, it's a requirement to report rather than a requirement to conduct due diligence. And as such, I think it has the potential, and which has been, I guess, realised in practice to become a tick box approach. One of the expectations of the legislation was to level the playing field in terms of how companies were reporting on steps taken to address forced labour, modern slavery in their supply chains. But I think what we're seeing in terms of corporate reporting is still a huge discrepancy between, Dame Sara, as you mentioned, the leading companies that are reporting very comprehensive modern slavery statements versus those that are really just adopting a tick box approach and putting the bare minimum down on their statements. So it has produced this kind of two-tier system in terms of how companies are reporting. And in addition, I think while it was a very valuable requirement and indeed, raised the prevalence of modern slavery in supply chains in the boardroom, I think we're seeing, as Katherine, you've alluded to, a lot of non-compliance with the Act. So even in this respect, WikiRate, which is a civil society organisation, did some research on on compliance with the modern slavery statement among electronics companies very recently, and they found that only 69% of companies had board sign-off of the statement that was available on their website, and even fewer companies had a statement available on their website, which is, again, just a very minimum requirement. And then I guess finally, just on the more critical side, I think, and this is something that Alex alluded to in the previous panel, I think one of the issues with having a Modern Slavery Act is that it really does separate modern slavery and forced labor, if we're talking about supply chains, from the continuum or the spectrum of labor rights abuse that can escalate to situations and conditions of forced labor. And so by diverting attention or by stressing that companies focus on this particular form of labor exploitation, I think it detracts from the preventative elements that companies could be doing in terms of protecting those labor rights of workers, from freedom of association, that's been alluded to previously, to recruitment fee charging, which is a serious contribution to debt bondage, and then forced labor as well. So I think that has been perhaps an unintended consequence of the legislation. I think how it could be strengthened, as Katherine, you've mentioned, and Dame Sara, this. I think the better approach, the best approach, is in terms of introducing human and environmental due diligence. So companies are identifying, mitigating, preventing, and addressing forced labor and modern slavery risks across their supply chain. So you have that inbuilt system of continuous monitoring, evaluating effectiveness, and then remedying when issues occur.
You're going too far into the future.
So, particularly with the omnibus. And then import bans, I think, also do have a role to play. So I'll stop there.
Yeah, okay. Let's start, Sofia, Section 54, what are your thoughts on impact?
So far, I think where we see most of the evidence is the one that has been produced by WalkFree and WikiRate. They have undertaken several analyses, taking a sectorial approach. So they have looked at the garments industry, the electronics, the renewables, finance as well. And it is really striking to find that in each of these ones, which were undertaken at different points in time, they have found that most companies do not comply with the minimum requirements. And the minimum requirements are really very minimum, right? It's just for it to be signed by the director, to be approved, and just to be published. So it's just admin, right? It's just that. And companies are not, most of them are not even complying with that. And I think it's really interesting to think about businesses as a heterogeneous group. So it's not all businesses. There are some businesses that might be best, like leading businesses, others lagging behind. Which are these type of businesses are we talking about, right? So I think it's important to think about how we might have different groups. But in general, the Modern Slavery Act has not had the impact that was intended based on these analyses that we find. And not only from WalkFree and WikiRate, but also the Modern Slavery PEC undertook in 2021 an analysis on the effectiveness of Section 54 and found the same thing, highlighted the enforcement issue about how important it was to have state enforcement rather than relying on civil society, etc.
Do you think if there'd been sanctions, more than the power to injunct, that would have made a difference? Probably, yes. I don't want to jump into the future. We're in the past, but probably yes. The other thing I wanted to mention was CCLA benchmarking report. And I think it's interesting to find as well that we don't see companies disclosing instances of forced labor in their supply chains. Mm-hmm. So I think it was also a hope that we would see companies stepping up and saying, we're finding this and that. Mm-hmm. And throughout these reports that I've mentioned, including the CCLA benchmark, we find that this is not happening. And it's increasing a little bit, but like by a couple of companies disclosing one instance and very vaguely. So definitely, I think in conclusion, it has not really had the impact that we have, that we had anticipated. But also, I think it's important to mention that it's not entirely possible to measure the impact of Section 54
by itself, right? Many other factors might influence business. And I just wanted to follow up on the reporting. So yes, Section 54 is a reporting measure, but it doesn't mean that you necessarily have to report nothing, right? It's a reporting regulation. It could require for you to report on specific steps, which is what mandatory human rights due diligence legislation does. So just because it's reporting doesn't mean that necessarily they can just say, I haven't done anything. No.
But unfortunately, that's what the law
That's
allowed.
what has happened with the
Exactly.
MSA, but
Yeah.
it's a complementary regulation, right? It's a different type of measure, transparency versus...
Let's just officially start thinking about the future then, okay? Because Áine's dying to get in. Let's go on. Are we all converts to due diligence here, mandating human rights due diligence? Áine?
Yes, I think that's definitely needs to be the direction of travel. I just wanted to come back on Sofia's point, because I think it's important. I mean, what we're seeing from KnowTheChain, because we benchmark UK-based companies and those that have to report under the UK Modern Slavery Act, and those that report under the Australian Modern Slavery Act. And there is a difference there. I mean, I'm not going to draw causation, but I do think there's a correlation between the additional required criteria under the Australian Modern Slavery Act and the UK one. And so even without going as far as requiring companies to conduct human rights due diligence, requiring companies to report on a set number of criteria does seem to come through in the reporting and the risk-based approach.
Absolutely, and if you remember, the independent review suggested there should be prescribed sections, and it was something that the government had committed to back in 2022, but unfortunately other priorities around immigration overtook that. I don't know what you're allowed to say about that, Katherine.
I mean, absolutely. That's the kind of history of where we've got to and where we are now. Look, I mean, it's all under active consideration. Whilst it's, there's kind of no formal government position, there's clearly a lot of interest, both in Parliament. There's the political will. So, the time is ripe to actually be really considering what some of these options are, whether it's mandating action through particular areas, whether it's something different from Section 54 and to due diligence. And it's really, for us as policymakers, about drawing in as much data and evidence as we can on the impacts of those sorts of measures so that we can make really considered advice about where we go to in the future. Sorry to go back into history a little bit, but Section 54 was a bit of a leap of faith. I don't think we're quite in that. I mean, that always makes policy officials nervous. So having that data to back up that this is the right approach and this is how we potentially manage unintended consequences. I know there's concerns around import controls in particular, and that we have a real thorough, wholesome, kind of united position that we know will work.
So there's a space for debate here which we need to get into. What about import bans? I mean, people sometimes say they're complementary to due diligence. Other people say they have unintended consequences, particularly for rights holders. What are your thoughts about import bans? Maybe Áine and then Sofia on I know the PEC have written a recent policy review of this.
Yeah, and I'd love to hear Sofia's thoughts. But I guess, I don't think they can be considered an effective mechanism to eradicate forced labour. I think they are a contributory or, to be enacted alongside a model of corporate due diligence that can be used as an additional disincentive for companies. Because exactly as you alluded to, Dame Sara, I mean, the only requirement with an import ban in terms of sanctions would be for well, not the only requirement, but a big requirement would be for a company to understand its supply chains and essentially, if it identifies forced labour then to exit that supplier relationship. And we know that that does not remediate forced labour necessarily. Now, there are certain instances, I would say, Top Glove and in Malaysia is an example where there has been change within the industry. But in general, I think it would need to be deployed alongside a due diligence regime where companies are taking a proactive risk-based approach to how they're addressing forced labour.
Thanks. Sofia?
Yeah, I think when we're talking about different measures, I think it's important to differentiate them and map them and see how each of them could play a role, right? So we're talking about transparency regulation, and now we're moving on to trade policies, right? When we're talking about forced labor import bans, it's a trade instrument. And then we're talking about mandatory human rights due diligence legislation, which is a different type of regulation as well. It's not trade based. So I think it's important to map them and see them as part of a smart measure. We still don't know how the smart measure looks like, but it's important that we continue having that that in the back of our minds of how can we play with these different instruments, which levers can be pulled and whatnot. So that's my first point. And the other one is that we also need to think about their role. So in terms of, for example, prevention, the UNGPs, human rights due diligence, as defined by the UNGPs and the OECD, its purpose is prevention. And that's why it's this process that companies have to do. While forced labor import bans, its purpose is not prevention. Otherwise, they would be designed completely different because they're not preventing. They're not preventing forced labor from occurring. They're preventing products from entering their market. But
it might have an impact.
It might have an impact, and that's something that we don't really know yet about how that would impact the actual prevention of forced labor. What does that mean for actual workers? Does it mean that these workers are having a better life, they're having better working conditions? We really don't know. And that was part of my third point, which is you mentioned unintended consequences of forced labor import bans on workers. And so far what we see in the evidence is that there's no evidence yet of having unintended consequences. So when we're talking about forced labor import bans, we're also talking mostly about the US Section 307 of the Tariff Act of 1930. That's also something important to mention because it's the one that has been implemented the longest.
But also UFLPA has been used an awful lot over the last 2 or 3 years.
Sorry,
the Forced Labour Prevention Act.
It's way more recent, and we do have some evidence, but definitely most of the evidence is Section 307 and some of the evidence with the UFLPA. But from that, we haven't found any evidence of unintended consequences on workers. But there's also not much research being taken on looking at what are the actual impacts on workers in the ground. Sure. So we do need more evidence on that level to understand.
That's a good call out for the PEC, isn't it? We need more evidence on this.
I have a long list.
But also, as Áine said, there are some examples, like the Top Glove examples, where there was definitely remedy for workers. What do you think about the fact that we know in the EU, there's a big question mark about CS-DDD at the moment, or it being watered down, but the forced labour ban, in December, yes, it will be going ahead in a few years' time. Do you think that if the EU are going ahead with a forced labour ban, and it's not just an import ban, it's an export ban and a move around the market ban, do you think there's a risk that we become a dumping ground in the UK? And is that more a political argument than a researcher's argument? What do people think about that? The dumping ground argument?
I mean, look, there's always that risk, isn't there? From a policy perspective, I think it will be really interesting to see how the EU's forced labour ban bears out, actually, and how that can work effectively, sort of independent of the due diligence requirements and various other requirements. It's also, we've seen the struggles with enforcement of a reporting requirement in Section 54. I think import controls also need a really strong enforcement response, and that requires resources. And I think, so from an operational kind of policy perspective, I think there's some real challenges there about how do you make sure that your any ban is kind of effective, is targeted at the right places, that minimises any unintended consequences, but basically does what it says it's meant to do. We struggle enough with drugs or other kind of illegal commodities, and trying to intercept and manage that is only more complex when the goods can't be immediately tested there and then, and you know exactly what that is. So it's a really tricky area, I think, operationally.
Okay. Yeah, Áine?
Just a quick note about, I guess, some elements of the of more progressive legislation, which we haven't touched upon, is this bringing in kind of civil and criminal liability in the case where it's been proven that due diligence hasn't been conducted, and I think that is extremely important. But going back to, I guess, what was said in the previous panel around how legislation is developed and how then it's enacted, I think if we look at the French duty of vigilance law, while there has been, which is kind of the most long-standing due diligence law in Europe, they have this built-in civil liability, but I guess over the years, the number of cases that have been brought and then the number of cases that have been ruled on in favour of victims, the process by which that's done has been deemed to be very complicated, and so victims are still lacking access to remedy, effective access to remedy, and then remedy when harm occurs. And I think, just summarising that, it's about how legislation is enacted and how that's communicated to victims and survivors and people who are affected by forced labour and modern slavery.
I mean, in all the work we've done on benchmarking, repeatedly the weakest area is remedy. I completely agree with you. Sofia, any thoughts on import bans?
Yeah, so I have 2 points. So the first one is just to build up on what we were talking. So forced labor import bans have had some impact on business behavior. So we do see some remediation occurring only when it is required explicitly when imposing a ban on a company's goods. But we also have seen changes in governments. So I invite you all to read that policy brief that we published a couple of weeks ago, because there are some case studies there, and you can see exactly what changes are associated to these forced labor import bans on both businesses and governments. Governments on the side of the affected by the forced labor import ban. The other point I wanted to make was on your question about the dumping ground, and it's something that I haven't found a definition anywhere. And so I would like to ask, what is a dumping ground? What is it? And aren't we already a dumping ground? What do we have in place to say that the products made with forced labor are not being dumped here? So what is a dumping ground, and what does it mean? What would be the different scenario now versus in the future once the CSDD is implemented or whatnot? So it's just, I would like to hear from everyone, what is a dumping ground?
To your point, we may already have one.
Exactly. We might already.
Bigger dumping ground.
Exactly. Maybe it's just going to be bigger.
And if you think about it, do you remember the case? It wasn't Top Glove, it was the other one. Was it Smart Glove? The issue about the government procurement. When all of a sudden that was on a government framework when the Americans had stopped importing them. So that was all dumping ground that was happening 4 years ago.
It's already happened. Exactly.
The issue is, I guess, whether if the EU is raising its standards even more, whether the risk is greater.
Yeah, I suppose. Exactly. It's something that we would have to
think about. Anyway, I'm very conscious that we're standing in the way of probably the Minister. I think I had a signal from, we're not going to be able to take any questions. Is that right, Owen?
No questions.
Oh, maybe we can take 2 questions because maybe the Minister's not here yet. Have we got some questions? We've got a lady here in a red and blue top next to the Bishop.
Hello, and thank you for your session. My name is Wally. I'm a lived experience. I'm a survivor. I just got my positive CG this January. My question is to Katherine. I want to know why, because you're talking of reporting. when a person is rescued, they go into the safe house. In the safe house, they have more protection than someone who's been rescued and still a potential victim of trafficking. In a safe house, you don't go to report. But the moment you leave the safe house, you go to a hotel or you go to Seiko accommodation, then you start receiving letters to go and report. Why is it so? Because a victim is a victim. Even when a victim has a positive CG, they're still required to report. Is it supposed to be like that? Because a positive CG means that person has been acknowledged by the government. So why should a person continue reporting? I was in a safe house, I wasn't reporting. I went to a hotel. I got a negative, they took me to a hotel. And then my asylum, they acknowledged I'm a victim of trafficking, but they said I need to go home. So immediately I started receiving letters to go and report. Meanwhile, I was rescued because of mental health. Mm-hmm. So my mental health escalated in the hotel. Then I had to talk to 111. They referred me to Black Country Women's Aid again because I was with them before, and they told my GP. So it didn't take long. They put me in a studio flat, but still there, I continued to receive letters. I used to go to report. Then I was sick because I have got a lot of health issues. I've got back pain, which I get steroids every 6 months on my leg from the perpetrator's house. And I've got diabetes and I'm on 3 insulins. So sometimes I'm sick, and with my mental health, I've got very severe low moods. I was told to still continue reporting. But when I was sick, I gave them sick notes from the doctors. I attended the GP, they knew I was sick, but they'll still send me letters. And my lawyer, from Duncan Lewis, will tell me go and report, and I will tell the person I'm not going to report. They should not force me to go and report. I have mental health issues. Sometimes I wake up, I don't feel like going, and sometimes I wake up with horrible back pains, and they have all the records. So another question is, why can't the Home Office communicate with the NHS England or UK NHS so that doctors, because sometimes you require letters. When I was in a hotel, they wanted a letter. I was on £8. From £75 a week, I went down to £8. I couldn't do much with it. I came from a safe house, which is also not a good thing to take a victim of trafficking who's been in a safe house, being protected, then you put them in a hotel where everybody is. Okay. Men coming asking for sex and all those things. Wow, at the same time, I'm a victim of, I was raped twice. So it was wrong to put me in the hotel with my condition. So the communication,
so can I,
they should learn to communicate.
So thank you for your question, and I'm really sorry to hear of the terrible experiences you had. I don't know whether Catherine's able to say
let me just ask for the last one for letters, because Home Office is always asking for letters from the GPs, and the GPs are requesting for a lot of money. So where can one get the money? Because they asked for a letter and they said they want my lawyers to pay £150, but I'm on £49 a week. Where am I going to get that £150 to pay for the letter? So there should be something that you should even tell the GPs, probably like a template to fill in something, and they send it straight to Home Office because they're charging us a lot of money. Thank you.
And you're making a good point. Do you want to say anything? Because it's not Catherine's part of the Home Office. Do you want to say anything?
No, look, and just to echo, look, I'm really sorry to hear of your experiences. It sounds really quite traumatic, and your bravery for telling us about it here. As Dame Sara says, it's not really my area, but do find me. Let me take your details. I can speak to people in the Home Office. It sounds like it's more about the reporting requirements of the immigration system, but that's definitely something that I can take on your behalf and explore with them.
Thank you, Katherine. It's Min on the end here.
Do I need a mic, or can I just shout?
There's one coming. There's one coming.
Hi, Min Deng, and Executive Director of Survivor Alliance. What I'll take from Boya's point related to this topic is that there's a lot of sanctions, we could call them, or fines, or consequences on victims and survivors that I would argue are not at the level of consequences, sanctions on businesses. And so to your point, I've thought about Brazil has the bad business dirty list, which I have not read the impact of that dirty list. But I'm curious about what are the sanctions and consequences that have been discussed regarding UK businesses that don't comply with even the bare minimum requirements.
A question on sanctions. We take one more. Lady here in the white sweater, 2 rows in front of Min.
Hi, I wanted to make a comment on the import ban question. I was most recently with the Coalition to End Forced Labor in the Uyghur region. We did quite a bit of advocacy work around forced labor import bans using the Uyghur Forced Labor Prevention Act as a model. Dumping grounds are where tainted goods are not allowed into a country that has such laws in place and then are sent to other countries that don't have such laws in place. And there are really clear examples that dumping grounds are increasing here in the UK, but also in Australia and Europe. We saw this with the tomatoes case that BBC covered a couple of months ago, where clean products were going to the US, tainted products were here in the UK and Europe. More recently, there was an increase of imports into Australia directly from companies that are on the entity list related to the UFLPA. So I do think that the more countries that have forced labor import bans, we will remove market access for those tainted goods. And I also do think there has been changes in corporate behavior in order to comply with those import bans, in that they are mapping and tracing their supply chain to try to identify exposure. Hopefully they do a responsible exit. In cases where there is state-imposed forced labor, we would argue that immediate exit is the only responsible course of action.
So thank you. I think that's comments more than questions, but it's actually putting the counter-argument on import bans, so Thank you very much for doing that. Does anybody want to answer Min's question on sanctions? What sort of sanctions are being discussed? What do we think should be the sanctions? Do you remember Lola talked about criminal sanctions that you put in your COPAC bill? Do we think there should be criminal sanctions, or do we think there should be civil sanctions? Any kind of thoughts on that?
I think it's a very interesting question. I don't think we have like 100% evidence on like the effectiveness of all of these different types of sanctions. If I'm not incorrect, the Brazil dirty list is only for public procurement. No, it isn't? Oh, okay, I'll just check that. But yeah, there's different ways of having this. Civil liability was like quite groundbreaking when the French duty of vigilance appeared. And I think you were making a point how important it is to have the civil liability, which just means that people can access remedy. And so it's not necessarily a sanction to the business, but it's like making it responsible for the harms and to provide a remedy to victims. But of course, it depends how this is implemented. So in France, we saw those issues about procedural barriers for actually people that suffer harms to access that remedy. Okay. So definitely, we've seen civil liability as a preferred mode of liability for businesses, like for justice. Although the German Act doesn't have civil liability, so we're seeing a bit of a mix.
Just very quickly, because I'm getting lots of signals.
Yeah, I would say that within that, I mean, it's so important that remedy is provided to survivors with engagement from and through and by survivors to restitute them to a situation where they're in before the harm took place, in as far as possible. So, you know, what we would advocate for is it's not just about a financial reimbursement to that person having survived, you know, exploitation and forced labor. It's really to bring that person back to a situation, reinstate the dignity of the person to before they have been trapped in these exploitative conditions. And so what we're not seeing from business is any engagement with rights holders or very limited engagement with rights holders on the issue of remedy, but that needs to be incorporated within any remedy that is provided to survivors. So, yeah.
Really good point to end on. Thank you very much to Sofia, to Áine, to Katherine. Can we thank them all in the usual way?